Good morning. We are convened for a hearing in case number 19 CD 1301, Almanzar versus Kiwi et al. There are two motions that are docketed, I think, to be heard. Really, only one that I'm going to entertain argument on, and that is the motion for summary judgment by the plaintiff. The motion for extension of time to respond. I'm going to decide that based on the materials that have been presented. But I do want to address it. The comments, I'm not going to entertain argument as I stated. I am profoundly disappointed that a party could ask for an extension, not receive the extension, and still file their response late. I mean, I can't fathom in what world anyone would think that's appropriate, because it's not. And I've looked at the law on this area, and it is debatable, I suppose, whether or not the court or any court must look at the failure to do something as to whether or not it caused any prejudice to the opposing side. I mean, arguably it didn't. I mean, I can't really find that a 2 or 3 day delay causes prejudice, but it is wholly unprofessional. I mean, you don't ask. I mean, I don't even think it is justified if you ask for permission. If you never ask for permission, and then you simply file it late. But I recognize people can make mistakes. But this wasn't a mistake. This was, we're not doing it. Not necessarily because of any desire to just be disobedient to what the court has said, that has ordered. But it wasn't an accident. I mean, when the time period came for the response to be filed, obviously the defendants knew that the time was running out. No notice was filed. No motion was filed at that time. No half-baked or written response was filed with a stated intention to supplement. Total silence, nothing. And then 2 or 3 days later, the response is filed, and there's no mention made at that time that it was even late, which was obviously known. I'm not going to put up with that again in this case. And it's not the first time that the defendants have done something like that. I don't know that I'm going to punish the parties for it, but if it happens again in any form or fashion, the defendant needs to expect that the attorneys are going to be sanctioned for it. If I thought I could report it to the bar of the state of Georgia that if it violated the rule, I would do that. And I'm going to review the rules of the bar to see if it does. But it is wholly unprofessional. It should not happen. I have to think back on my own career as a lawyer and what would I have done under the circumstances. I had a case one time where a party came to me and wanted me to file a slander suit. Coincidentally, one of the claims in this case, thought he had a pretty good case, but time was running out. Slander has a very short window of the statute of limitations in Georgia. At that time it was a year, and it may still be a year, but that's what it was. And on the day before the anniversary of the slanderous statement. I knew it was a 1-year statute.
Posted the story, the plaintiff then, immediately started posting about on her social media, on the plaintiff's social media account about,
So she thought the plaintiff was actually, at the time that she received this message, she really thought this was the plaintiff doing this?
Correct. I mean, she said yes.
And she thought the plaintiff was trying to set her up, so she'd just go ahead and take the bait and put it all out there.
Which her purpose was to show that the plaintiff was trying to set her up so then the plaintiff could then go and claim that she posted fake stories.
Yeah. Well, if there's a trial in this case, I hope she has a better story than that, because that makes no logical sense. I mean,
she probably be able to explain it better than I can, but that's the information that I have.
Well, there needs to be a serious evaluation of your case. If that's the defense that you're going to present to a jury, that she knew all along it was false, and she thought it was the plaintiff. She didn't believe it was true, but she went ahead and published it anyway. But when she thought the plaintiff was trying to set her up, no reasonable person would do that. I mean, that makes as much sense as nothing. I mean, so that's her source. Then if assuming that to be her source, she claims T.I. is the source for some things. Did she know who T.I. was?
No, Lovely T was never a source for anything.
Lovely T, is that it? It's not T.I., it's Lovely T?
Lovely T is the name of the blogger, yes, sir.
So Lovely T was not a source for any of these allegations?
No, what happened was Ms. Jones posted a video on her own Instagram account that went viral, that was about the plaintiff. That's when my client, the defendant, reached out to Ms. Jones for an interview. That's what whole that's how it was set up. During as she was talking to Lovely T, they used to be friends. Lovely T also has a YouTube channel. She also does the same thing. They post celebrity stories on their blogs, on their YouTube channels. She was talking. Lovely T is the one that I believe even told my client about the Jones video, the one that went viral from Jones's Instagram. When they were talking, Lovely T said that she might have had some receipts that show that some of the things that Ms. Jones was saying was not true, but she never produced or gave my client any of those things. My client.
Okay, so I got you. I was confusing Lovely T with being the source. Lovely T was the person who told her that some of these things might not be true. But I got you. Okay, I'm not really too interested in the stuff that Ms. Jones provided to her. At this point, I was more interested in the things that she said she had, or at least the plaintiff's attorney said that the defendant did not have a source for.
The source for some of the statements was obviously the things that Ms. Jones said to her in the interview, coupled with there are again numerous videos of the plaintiff herself on the internet talking about these herself.
Yeah, I think at one of our last conference that we had, I'm not sure what that might have been a motion to dismiss. Or the discovery dispute. That's probably what it was, that day-long hearing on discovery dispute. At least by then, I had made a statement that I questioned to some degree the plaintiff's claim for damages, given the profile that she has as a performer. Certainly, the music videos that she does are very provocative. And that's probably a very mild way of describing them. Of course, a lot of that goes to damages, I suppose. But I guess you could argue that some of it may even support some of the allegations that the defendant made about her. not all of them for sure, but maybe a few of them. But the more fundamental question I have for you, as it relates to these videos that you have, and I looked at your videos. How do you propose to make those admissible? To the extent that they are compilations, your client didn't, I'm presuming, didn't put them together, that she might have downloaded them from somewhere. It seems like the reasonable thing to have done would have been to have taken the plaintiff's deposition and show her the videos and ask her, is this her? Is this you performing or saying things or doing whatever? But you didn't do that. So how is it that you're going to get those admitted?
Well, the videos are, and again, no, my client did not put them together. It's the same situation with, it's the defendant, I'm sorry, not the defendant, the plaintiff, using her, Instagram Live or her Instagram profile and posting those videos where she just talks. They're not, music videos or videos of her perform. This is just like her, she gets on the live and she's just talking to her fans. Now, some of these videos that I'm referring to specifically as it relates to her making these statements that she was herself a prostitute. She refers to herself as a quote, and this I'm quoting, a stripper hoe, end quote. In these videos, she has had a huge social media following even prior to her actual, music career taking off. So she has had, her Instagram has been active for a long time, even before she, started becoming, an international celebrity. So some of these compilations are, it's people on YouTube, obviously, that put them together, but it's clearly her in the video. She has the same handle that she has now on her social media profile. So, we have not, again, this is the first time I'm hearing of those videos might have been doctored or, being edited. We certainly didn't edit them. We produced to the plaintiff as we, downloaded the video, as we found it on YouTube. They have not provided us with any videos, with the full videos from any of those clips. If they're saying that that the videos are doctored, then I would have expected to see, video, because their client is the one that posted those videos online. She's the original source of the videos. So whether someone else on
maybe. That may be true. That's maybe logically true, but that doesn't necessarily mean it's true. I
don't know of any other way to get your own Instagram, an Instagram live video from your profile with your face on it to the internet, other than you being the person that posted or the user.
So I took a plea yesterday, and I've taken probably 20 pleas in the last year about people sending emails to companies and other companies sending millions of dollars to bank accounts based on these emails that look like, and for all appearance purposes, to the sender are the email addresses and bank accounts of the companies within there doing business, but they're not. They're spoofs, they're email scams, they're romance scams, all these things are occurring. It's not an admissible document simply, or video simply by saying McCall's. There's a procedure you can go through. And one of the ways was to take the plaintiff's deposition and show them to them and say, is this you? Did you say these things? She may have said yes, she may have said no, but you didn't do that, so you don't have that today. Now, you submitted them to us, so I guess we can look at them, and I guess we're all familiar with what the plaintiff looks like generally. And so perhaps under the federal rules, I can surmise that, well, there is a way for you to make these videos, or at least parts of these videos, admissible at trial, because the plaintiff will be here, and you can ask her. And if the plaintiff wants to make a motion in limine that we have that discussion outside the presence of the jury, so that you can ask her about these videos before you try to move them into evidence, then I suppose that we can do that, or you can even make that motion, I suppose. But as far as I know, that's really about the only way you're going to be able to get them into evidence. It's not... You couldn't put a witness on the stand who says, I've looked at this video, and this video is the plaintiff. The law doesn't allow you to do that. The jury could do that, I suppose.
My plan was to ask the plaintiff, to get it into the plaintiff, because they depict her, and presumably, they depict her to my knowledge and understanding. So that was the plan, to how to, authenticate them, because
Okay. So let me ask you about the Pornhub video. Did your client admit that she knew that was not the plaintiff when she published it?
No, Your Honor. And, in fact, what she actually testified to her deposition was that somebody sent her a link to that video, to her DMs, and she reviewed it, and it looked.
She thought it was the plaintiff.
Correct, because it's in the setting of the video is inside of a strip club, which the plaintiff used to work at a strip club, and it looks like the plaintiff. So that was.
So the plaintiff is presumably going to testify at trial that is not her, that she did not engage in anything of the sort as alleged. And so there's her testimony. And then your client certainly doesn't know, and in trying to defend herself, I guess you're going to ask the jury to take a look at the video to determine whether it was reasonable for your client to assume that was in fact her, so that she could then go report that she saw the plaintiff doing these things. Is that the way you anticipate this will work at trial?
That's what I was anticipating. Yes, Your Honor.
All right. Anything else you want to say about the legal claims the plaintiff has asserted themselves, the intentional infliction claim and the slander claim?
Yes, Your Honor. Just briefly. Just wanted to touch upon a couple of things that Ms. Matz talked about in her argument.
Videos didn't say she had STD of any sort, did it?
No, the videos that I'm referring to were mostly discussing the drug use and the prostitution and the stripping.
In that initial interview with Ms. Jones that kind of began all this, was there any discussion then about the whole thing with the beer bottle? Did that come after that?
No, that wasn't mentioned at all in that. To my recollection, that was not mentioned at all in that interview.
All right, so what you're saying then is, okay, so this lady, does she know, by the way, did your client, prior to seeing Ms. Jones' statements, whether they were in written form or video form, and prior to interviewing her, did your client know Ms. Jones? Have any information about her veracity about anything?
No, no.
And so your client took what Ms. Jones was telling her and what Ms. Jones was claiming, and then she was taking the public profile that your client was aware of and saying that was enough. And so I'm going to publish this stuff that Ms. Jones is saying because I think I've got enough there. I mean, there's nothing I'm missing about what your client was relying on when all this first began. She started saying this kind of stuff.
The statements that plaintiff made herself out of her own mouth.
Well, I was including that in the public profile.
Oh, so, yes. Then yes.
So public profile plus Jones, and so that was enough for her.
Yeah, and to be clear, in the Jones video,
her being the defendant.
Yes. To be clear, in the Jones video, they what neither Ms. Jones nor my client, the defendant, ever said that the plaintiff had any STDs. What Ms. Jones said was that the plaintiff, had cold sores on her mouth during the time that she knew that they knew each other, or that, during that short time that they worked together at the strip club. So that's all that was said about it specifically. I believe, in fact, Ms. Jones specifically said that she was not talking about herpes of.
Did your client later refer to the plaintiff as herpes B?
She did, but
that becomes a statement of fact, doesn't it? if I referred to Judge Roy Moore in Alabama as child molester Moore, I mean, that would be implying that I gave credits to the allegations against him, or I could pick anybody, O.J. Simpson as Killer Simpson. I mean, when she called her herpes B, the B being a part of her stage name, I mean, that's a statement of fact.
I mean, she also referred to her as cold sore B. Those were interchanged, she interchangeably referred to her as both, and cold sores are obviously medically known as herpes, so that's really where that all came from.
Cold sores are what now?
Cold sores are herpes. Like, the medical term for cold sore is herpes, so she has never said anything about the client. She's talked about plaintiff having basically cold sores. There's pictures that appear that the plaintiff does have cold sores on her mouth, and so that's all that that they were talking about. They were not discussing her.
You're going to have testimony in this case that that a cold sore must mean that you have herpes.
I mean, it's not. If you have cold sores, that's what they are. They're herpes.
Okay, I understand that herpes may manifest itself in cold sores. Are you saying that cold sores always mean that someone has herpes?
That was my understanding.
Okay. All right, I never heard that before. So you may be right, but I can just remember in middle school knowing people with cold sores and never knew they had herpes. I'm not sure that is right, but I'll take your word for it, at least right now. So your defense then for the defendant on that is that when she said she called her herpes B, she wouldn't say anything that wasn't true.
Correct, Your Honor. Our defense is that these statements are true. That's basically the defense for the most part. Yes.
Anything else, Tom?
Just one more thing in regards to the intentional infliction of emotional distress. I believe Ms. Matz had mentioned that they had provided us psychiatric records, and I just wanted to mention, because we did discuss the same thing about my client, the psychiatric records that we've received, they involve two summaries, typed out summaries, just like the ones that we sent. The first summary was made on October 26, 2020, and it's titled Therapeutic Coaching Summary, and it relates back to a session that the plaintiff had with this this coach, this therapist, or whoever this person is, back in 2018. So again, 2 years later, a summary is typed up. And then on December the 7th of 2020, we received a second summary that was called a psychological treatment summary that basically stated that the plaintiff followed up in November of 2020 on her November 2018 session with this therapist. So we don't have any records that were made at the time of the treatment of the plaintiff. So.
I'm sorry, why are we talking about the plaintiff?
Because I believe Ms. Matt said that to prove the IIED claim, the plaintiff's IIED claim, they had submitted the psychiatric records. So I was just wanting to let Your Honor know that those are the same as the records we submitted.
The statements of whatever they are from the therapist that the defendant saw, you recognize those statements are not admissible, right? They don't come into evidence because they are testimonial, they weren't contemporaneous, they weren't business records. There's really no exception that allows you to go back and to have a therapist create a record for purposes of the lawsuit to make it admissible. Not that I'm aware of. If they were contemporaneous business records, they might be admissible, but not otherwise. So how are you going to get that evidence other than your client saying I saw a therapist?
Well, the therapist will be testifying. Okay.
All right. Well, just make sure y'all consider the fact that these litigation-based documents are not admissible, to my knowledge. You may look at the rules and find that I'm wrong, but I'm not aware of any rule that's going to allow a document created for litigation to be admissible into the record of the case. Anything else?
No, I think that basically sums it up. I mean, the gist of our argument is that, you know, our defense is that the statements were true, you know, their contentions that they're false. And so because there is a dispute as to whether the statements are true or false, that we believe
the only evidence that, okay, so I was just doing some research about cold sores. There's two different types of herpes, and one is reflected by cold sores. As far as the HPV, I'm sorry, you have no source for that and agree, right? For HPV.
correct.
Other than, do you have a source for the HPV?
No, Your Honor. For the HPVs, that video
But you're saying that was not really an accusation. That was just sort of a matter of jest, or either of a matter of inquiry, I suppose. As it relates to the prosecutor, you say that her own videos establish that and make that reasonable, along with Ms. Jones.
correct.
Drug use, I guess the same, right?
Yes, Your Honor.
Okay. The issue of adultery is this unattributed account that DM'd your client, right?
Yeah, and I believe the video is Plaintiff's Exhibit 25 that they submitted along with their motion. So that's the video that we're talking about.
And the debasing acts is it looked like her to the defendant. In the video that she was provided,
yes,
it looked like her. Okay. Anything else you want to talk about?
No, I believe that's it.
All right, thank you. Ms. Nash, do you have any follow-up?
I apologize, Your Honor. I was on mute and I started talking. Yes, I do just have a couple of short follow-up points. I'm not going to belabor what Your Honor's obviously already caught on to, and that is that, you know, these anonymous sources and the way he publishes her videos is no reasonable person would accept them as true, and she's acknowledged that they were not. You know, Ms. Ismailova saying that there's an issue of fact here, there's not one. There's not any facts in the record that any of this is true, actually. There's no admissible facts in the record that it's true. The only admissible facts in the record are that these statements are untrue. As to the beer bottle thing, I do have a specific thing I'd like to say about that. That what Ms. Ismailova just said is not true. It's not what Ms. Kebe testified to. Someone did not send her the video link. Someone told her about it. She went on Pornhub. She had to search for it. And in the process of searching for it, and we've submitted this with our summary judgment motion, she literally ignored other search results that were right in front of it, where my client was saying that is not her, and other articles saying that is not actually of the plaintiff. So this video that, you know, she's saying was on Pornhub, our client has affirmatively testified in her affidavit that is not her. It does not depict her, and it was known before Ms. Kebe said stuff about it, that this was not actually my client.
Let me follow up about that point, okay? Sure. So your client said at the time, your client says today that that's not her. That doesn't end the inquiry, really, does it? I mean, doesn't it really depend on whether or not a reasonable person could look at that and think that it's your client?
I don't think it does in terms of whether or not it is actually my client. They would have to have some evidence that that is my client, and there is none. Summary judgment is about admissible evidence.
Well, yeah, but they could do that by looking at it. I mean, if it looks like your client, that goes in one hand, and if your client says it's not you, not her, that goes in the other hand, and that has to be balanced. I mean, I'm certainly familiar with lookalikes and things like that. know about this video that you're talking about, but I mean, if we assume for a minute that it does look exactly like your client, maybe because it's just a person that looks a lot like her, or maybe through some kind of alteration that went on to create it. The question becomes whether or not it's reasonable for the plaintiff, for the defendant, to rely on her belief that it looks like your client to say what she said. I mean, I'll give you another example. I mean, heck, let's need only go back to the last. I don't want to say anything that gets me in trouble. So this whole discussion about alternative facts. There have been times where people in high places have said they never said something, but yet we've seen videos on the news where they said it. And I don't have to rely on the person saying they didn't say it if the video shows me that they did say it, unless they can demonstrate that the video is itself a fraud. I think y'all know what I'm talking about. I'm trying not to be political here. So my point is, if this video looks like her, is she not entitled to rely on it, even if your client says it's not her? Even if your client said that to her before she ever published it?
So I think in the circumstances, no, because it doesn't look like her. And she knew that the website it was uploaded to is user-based uploading, so there's no veracity to anyone verifying who's in any video. There were other public articles about the fact that that was not my client that would have showed up in the search results that she did. And she admitted that she wanted to publish it to get back at my client. So, taking all the circumstances together, I don't think anyone reasonable would actually think she thought that was my client.
Okay.
The other point
is that video in evidence, or a photograph of the person's face in evidence from the video that we can look at?
I believe the defendant submitted the video.
Okay. How did they submit it? We can't access a link to a porn website. What I'd like to do is have a picture of the face of the person, and nothing more.
We can do that if Your Honor wants. We did not submit the video for this, for this motion, like in response to this motion.
Oh.
But we do have it, if we can either submit the full video or take I guess.
So what I've got now is your client then saying that I looked at a video and it looked like, and I believed it to be the client.
Correct.
And, okay. Are you Ms.
She didn't republish my client didn't republish the video that she thought that it was the plaintiff in her own video. So that's not.
No, she just talked about everything that she saw.
So it's not published in her video though. I don't know if that's what you were asking.
No, I'm just saying that if we have a trial on this point, you're probably going to have to admit the video and the evidence, because the jury's going to have to know whether or not it was reasonable for her to believe that it was the plaintiff. And if it doesn't look like her, and she will be before the jury, and certainly everybody generally knows what she looks like, at least from, the face up, then if the defendant is saying, I thought that was her, it doesn't look like her at all to all the jurors, then that's a big problem for her, being the defendant. Because she's basing her defense on, I acted reasonably, I thought it was her, it looked just like her. So, Ms. Mance, anything else?
Yeah, a couple of other things. Ms. Ismailova has made a couple of other blatant misrepresentations I just want to correct. In the Jones video, they did use the word herpes, and I apologize, but I think that it's extremely disingenuous to be arguing anything else at this juncture. I mean, I'm happy to read you the transcript, but saying that she didn't say herpes, she said she had cold sores is, frankly, it's just a lie. The Jones video says, here we go, I'm reading from a quote. Kibi, this is Kibi asking the question. Kibi, she has herpes, ? Jones, yes. Kibi, so you were living with her at the time she said she had herpes outbreaks on her mouth, ? Jones. Yes. And I mean, there's so many other instances of her using, herpes. Your Honor's aptly pointed out herpes B was a way to, say that she had herpes. She said it in other videos as well. In April of 2020, she said, Schemo apparently gave plaintiff herpes. I mean, we've quoted a lot of these in our statement of material facts. Our statement of material facts is very long and detailed. We've put forth many, many instances of these things. I would also like to just touch on the video that she's claiming is a joke. First of all, she says in that video several times that my client committed an infidelity act. I believe she says it in that video 7 times. And what she actually says about HPV wasn't what Ms. Ismailova said. At the hour 16 minute and 11 second mark, she says, I know you got HPV. Can I confirm it? No, but Dr. Sebi's people can do something about it. And you know what? The defense that I was joking when you're accusing someone of having a sexually transmitted disease, I mean, it's not a realistic defense, and the court can absolutely decide to disregard that as a matter of law. These things aren't funny. And, regardless of my client's past, where, she was a stripper at a period in her life, and regardless of, that piece of her past, that doesn't mean that she has STDs, and it doesn't mean that, even though she is a famous rapper and, a musical artist, she's also a mother and she's a wife. And the fact that she, for a period of time, was a stripper doesn't mean that it's okay for Ms. Kebe to go out and slander her in this way. Even to the extent the court is going to, give some consideration to my client's public profile, it just doesn't go as far as Ms. Kebe has taken it. Those things it's not funny. It wouldn't be funny if someone accused any one of the lawyers on this call of having, or, anyone of having a sexually transmitted infection. That's not funny. And if Ms. Kebe thinks it's funny, she's the only one. The other thing I just want to mention, Ms. Ismailova keeps saying that my client has admitted to being a prostitute. My client has admitted no such thing. The video she is talking about is, again, one of the ones that was edited. My client was dressed up in a Halloween costume. And that would seriously be like me dressing up in a Halloween costume as, the Hamburglar, or, putting on a suit and chain, and then someone saying about me publicly that I was a thief or that I had embezzled money, and saying that because, I dressed up as a Halloween, which the clip that they have submitted doesn't show this, but the remainder of it, and I don't even know when this video was taken, frankly. This was not on my client's Instagram profile, and, Ms. Ismailova keeps making it seem like these videos are all coming from the same place, but they're not. But it is very clearly a joke, and a Halloween costume, and someone talking about how they've dressed up for Halloween. And, again, that doesn't mean it's okay for Ms. Kebe to take, that and then go out and say that my client has sexually transmitted infections, and that she actually is a prostitute, and that she's trick rolled people, and, all of these other things that are blatantly untrue. And there's just no evidence in the record that they are true. The other thing I just want to say is that, Ms. Ismailova continued, what she just said about this video of these beer bottles, this beer bottle situation is not even attached to their summary judgment motion. I mean, summary judgment has a very serious purpose, and that's to make people present their evidence so that the court can evaluate whether or not a reasonable juror could find in someone's favor. And they haven't even come close to providing any admissible evidence or evidence that they could find admissible. They didn't even submit that video. They just want everyone to take their word for it that it looks like her. And I think it strains credulity to the point where the court could very easily find that no reasonable juror taking any of the evidence that's in the record before Your Honor could ever find that any of these defenses have any merit. Unless the court has any other questions, we'll rest on our papers.
I'm just impressed that you would pull Hamburglar out, because I'm sure that's got to be after your formative years of cartoon watching or commercial watching, but right in the middle of mine. So I certainly acknowledge that. All right, so I'm not gonna rule today. I am gonna set the case for trial during the summer months, regardless of what I rule and how I rule. We will have a trial. I think it's important for both parties to. Well, we'll have a trial unless y'all settle the case, okay? Because under either side's argument today, there are issues left for a jury, and we're not absent some reoccurrence of COVID that changes where we're headed at this point in time. Then you could bank on the trial date that I've given you. In fact, I'm going to have my staff today or tomorrow send out a notice to you that the case will be set for trial on that day, and so don't make any plans during that period of time.
Your Honor.
Your Honor.
Yes.
I actually did check my calendar at the break. I actually do have a vacation scheduled the last 2 weeks of our. I mean, I'm hoping for no recurrence either, but I'm actually taking a trip to see some of my family who I haven't seen in a very long time. There's a important birthday around then. Is there any way we could do it in September? I mean, not long after.
I could probably find a date in September. I'm going to do it before the end of September. Yes, ma'am.
Yeah, I was just gonna say that I also have a vacation plan from the 14th to 20th of August, so if there was any way we could do it after.
Okay. Well, I will put it in on my first calendar in September, and I don't know that I've planned out that far. It seems like we've got a fairly late. I don't have my phone up here. Can you look? You got your phone? You look at a calendar or something. What is Labor Day? It seems like it's kind of late. Like maybe like the end of the first week of September this year. The first Monday. What's the first Monday in September? First Monday is the 6th. Okay. So go ahead and count on the trial beginning on September the 13th, which is the second Monday of September. Because I don't want it to be on Labor Day. So, probably I would say a week or less is what we're talking about in this trial. But your clients need to be available, and you need to be available during that period of time. If you call me up and tell me later that, Judge, I can't do that day, I got something else to do that day, I'm probably not going to accommodate you. So, let's don't go down that road. I'm scheduling this way enough in advance where you got notice of it. The only problem comes if you have another federal judge somewhere who's saying you got to be in court that day. He or she and I have to kind of work that out, but I suspect I can probably win that battle with them.
Your Honor, could we have a day or two just to confirm with our clients that they don't have anything previous scheduled? I'm not saying they do or they don't. I just would like to at least confirm if Your Honor would indulge us.
You can ask. I'm not promising you that I'm going to accommodate a plaintiff who has filed this lawsuit saying she's got somewhere else to be for business. Look, everything's going to start going, right? I mean,
yeah.
So everybody's going to have conflicts. My intent is to have this case tried by the end of September. So,
okay. Thank you.
If she's serious about the lawsuit, then she'll make it her priority. But you can ask, and if you come up with some extraordinary thing, then bring it to me and I'll consider it. But that's the day I'm going to send out a notice for. And I can't recall whether y'all tried to sell this case through mediation or not. Look, folks, there's going to be a trial of some sort. So from the plaintiff's perspective, whether she obtains summary judgment on some or all of these claims, she's still got to be here. She's still got to testify. She's still got to have a lot of this stuff talked about. Same thing for the defendant. And honestly, if you just look at the evidence that we all know is out there, I got to say it's a much greater probability that if this case goes to trial, completely on everything, that the plaintiff's going to prevail in a lot greater way, and there's certainly more money on the line for the defendant than I think for the plaintiff. Could be wrong about that, but that's my assessment. So one thing I'm not going to do is I'm not going to continue the case in August or July when I get called and say, Judge, we need some time to talk. Can we take the case off in September? My answer is going to be no. Cases when it is. If y'all want to talk, you got between right now and the call of the case for trial on the 13th of September to work it out. I mean, you can work it out during the trial if you want to, but that's certainly a waste of the judicial economy and your own private resources to put all that work into it. So if you want to talk and try to work it out, you need to do that now. Can't tell you exactly when I'll have an order out.
Check the mic and make sure it sound right, boy. Check the mic, make sure it sounds